The financial industry has been split over the veracity of the U.S. Securities and Exchange Commission's charges ever since the watchdog launched legal action against Ripple Labs for allegedly selling unregistered securities in the form of their cryptocurrency XRPI. Since 2020, the case has undergone a number of changes of direction, but no significant decisions have yet been reached. Recent developments, however, have indicated that Ripple might be in the lead for the time being because it won a series of crucial motions that could prove crucial in proving its fair motion argument. In particular, the court last week decided in Ripple's favor to unseal two crucial documents, which the firm argues would reveal how the agency categorized XRP back in 2012 when it initially entered the market. Attorney Joseph Hall, who focuses on capital markets and digital assets, recently recorded a podcast in which he expressed sympathy for Ripple's due process defense, which maintains that the business was not given adequate notice that its acts were illegal despite having been in operation since 2012, added he. I'm unsure of what the SEC intends to demonstrate through the XRP litigation either. I'm still baffled as to why the SEC chose to file the lawsuit. It is still unclear who will win the lawsuit, though, as the months before were mostly distinguished by a number of discovery arguments and delays from both parties. It should be emphasized that more than 65,000 XRP holders have joined the proceedings, which are being handled by attorney John Deaton, expanding the lawsuit beyond the original two parties. In the same ballpark, Hall noted, it is rather convincing that the investors themselves are expressing a great deal of dissatisfaction and worry here. Although it may be important to the judge, I don't believe the judge will let the XRP community's fury influence their decision in any way. Nevertheless, he stated that since the discovery phase of the case is coming to a finish, substantial action over the course of this year might be anticipated. A settlement this year would be extremely difficult, according to Hall, because litigation proceeds slowly and appeals can be anticipated at the district level where the issue is being contested, unless, of course, both parties agree to a settlement which, according to Deaton, is improbable at the present given the SEC's continued protection of records the court has ordered it to make public. The report that SEC Chairman Gary Gensler is quitting from his position at the regulatory body Pro-XRP is sweeping Twitter right now. In response to the rumors, Attorney John sharing his thoughts on several seldom-spoken neighborhood concerns. This ruling authorizes a large number of XRP purchasers to launch securities lawsuits against Ripple and its subsidiary XRPIZO Bradley Garlinghouse. The primary grievance is Ripple's failure to comply with federal and state rules in that it did not register its digital asset extract as a security. The most recent court date in the XRP investor class action lawsuit filed against Ripple was 2 months ago. The main plaintiff, Bradley, filed a request to assemble a class of global XRP owners who purchased, still hold, or have sold XRP at laws despite Ripple's international presence. This order affirms the right of investors in the United States to seek legal remedies. The counsel for the defense was successful in arguing that the lawsuit should be restricted to investors in the United States. Judge, she emphasized the importance of allowing individual jurisdictions to enforce their cryptocurrency regulation and added that this ruling marks a significant step forward for the lead plaintiff and his legal team, who allege a loss of $118,000 after selling XRP in 2018 due to various reasons. Hamilton acknowledged the changing legal situation around cryptocurrency in this complicated legal. Chief Operating Officer of Ripple Labs, a decision about the SEC versus Ripple litigation is expected to be made by August 10. According to pro-XRP lawyer Fred Raspberry, Judge Annalisa Torres will hand down the summary judgment in the case by the end of September. Raspberry derived this using Judge Torres's prior summary judgment data at the time of writing on Monday. The cryptocurrency was trading for more than 4 cents, while extra holders wait for the outcome of the litigation and Ripple's future actions. While the cryptocurrency market waits for the conclusion of a lawsuit brought against Ripple by the United States Securities and Exchange Commission state, the cryptocurrency's price continues to move in a strong upward trajectory. Legal expert has presented more reasons in favor of the blockchain firm side of the legal fight. Indeed, in a tweet on July 2, lawyer Bill Morgan joined a discussion with well-known XRP community member and former Second Enforcement lawyer Mark Fagel, in which the former informer asked why the regulator filed no injunction at all if Ripple did anything nefarious or even illegal besides selling unregistered securities. What is the point of protecting invest in the company? Judge Phyllis J. Hamilton of the United States District Court for the Northern District of California has granted class certification in the sharing his thoughts on several seldom-spoken neighborhood concerns. This ruling authorizes a large number of XRP purchasers to launch securities lawsuits against Ripple and its subsidiary XRPIZO Bradley Garlinghouse. The primary grievance is Ripple's failure to comply with federal and state rules in that it did not register its digital asset extract as a security. The most recent court date in the XRP investor class action lawsuit filed against Ripple was 2 months ago. The main plaintiff, Bradley, filed a request to assemble a class of global XRP owners who purchased, still hold, or have sold XRP at laws despite Ripple's international presence. This order affirms the right of investors in the United States to seek legal remedies. The counsel for the defense was successful in arguing that the lawsuit should be restricted to investors in the United States. Judge, she emphasized the importance of allowing individual jurisdictions to enforce their cryptocurrency regulation and added that this ruling marks a significant step forward for the lead plaintiff and his legal team, who allege a loss of $118,000 after selling XRP in 2018 due to various reasons. Hamilton acknowledged the changing legal situation. This paves the way for additional investors in XRP to participate in a class action lawsuit and seek compensation for their purported financial losses. The attorneys for Ripple and Garlinghouse, who are defending themselves in this case, argued that class members' perspectives on the matter of the departure security status varied widely, which, in their judgment, would cause strife within the class judge. On the other side, Hamilton was quick to dismiss this point, saying that any complaints could be settled through the standard opt-out procedure. Nick Spear of Susanna Godfrey voiced his displeasure with the decision made by the court while the proceeding of the case continues. A spokeswoman for Ripple emphasized the court's rejection of a worldwide class and the significance of allowing other countries to regulate cryptocurrencies independently. According to Trend Pro Ripple lawyer Fred Raspoli, the lawyer emphasized that 60% of the federal judge's rulings came between 146 and 330 days, with the judgment announced in an average time of 249 days, using statistics related to the motion summary judgment of the United States District. It is no longer legitimate. Resupply also provided hints that the 330-day rule could be applied in the SAC fee case involving Ripple Lab, and if that were to occur, Deaton decided a case in which her summary judgment decision came 6 months after her Daubert decision. Therefore, if her Daubert ruling was made on Deaton, stated in a live video, Ripple Laboratories' previous statements made by Geo Brad Garlinghouse indicate that the ongoing legal battle is drawing to a close and that the judgment could be delivered within the next several weeks.